Hello, hi. In today's recording for commercial law, I want to look at a very popular or common area that comes out in the syllabus. And if you take a look at this slide and this question, this is question 6, 2019 of the October paper. And one look at the question, and if I were to ask you on which topic or area that this question is on, I'm pretty certain that many of you will get it right. This is concerning Zhang, a buyer who buys a painting, and the painting turns out not to be from the original artist, and advise Zhang, the buyer. And straight away, there could be two answers you're giving me. You may say, for example, your first answer to say, well, this is a contract or an issue involving sale by description. And yes, you say that you're right. Or you may say, well, this is a question concerning SOGA, section 13, sale by description. And if you say that, that is wrong. It is wrong because this does not involve SOGA. It is not section 13. Rather, this is a question involving the Consumer Rights Act, and there will be a different number or different section that would apply. And if you look at this question, whilst we remain on this slide or on the screen, you can see how clearly in your third paragraph, the examiner has specifically highlighted that Zhang is not an art dealer. Now, of course, it may still be argued that he is a commercial person, he is a non-consumer, but I want to interpret the question with a highlight by the examiner to indicate that he's not an art dealer, to show how, therefore, he likely would have bought the painting as a consumer. He is a collector, right? And very often, these collectors are not in the business of selling paintings or buying paintings as a business. It's more of in their own individual personal capacity. And so because we construe or interpret this question where Zhang is a consumer, therefore we do not wish to apply SOGA. So for students who answered the question in October last year as a SOGA question involving section 13, that would be a wrong answer. Now, so in your answer structure, you want to start off by being able to identify the issue. And the first issue, of course, is for us to determine what would be the available remedies for B insofar as a breach of contract, focusing on breach of which statute, which statutory implied term. And then, typically now, what would be the available remedies? And a lot of times, students would focus on the first issue. I've seen that often, and either because they don't know the answer, or they have no time, or maybe they don't realize it is required, they fail to discuss point 2. And that is, I suppose, the purpose of me doing this lecture with you, for me to highlight that point 2 is important. Because the moment it involves the Consumer Rights Act and a consumer buyer, there are additional remedies that a consumer buyer has under the CRA, which the buyer under SOGA will not enjoy. And so that's why this is a very good question that allows for the examiner to test you on CRA, and then the additional remedies that the consumer buyer has, which is not found in SOGA. Right? So there are these two distinct parts of the answer. Now, starting, of course, with the first part, of which relevant statute will apply, it's a two-part test. The first part of the test now is where we want to ask, is it CRA? And in particular, of course, whether or not is there a trader and a consumer, right? It's a B to C contract, but don't use the word B to C, although it's not wrong. The correct term to be used is T to C, right? Trader, consumer. That's the name used or the label used in CRA, a trader and a consumer. And it's a two-part test because only where the first part fails, where if we conclude that it is not a trader to consumer transaction, then we discuss the second part to raise SOGA, right? And that's how we want to discuss this particular first part of our answer in first. as a preliminary issue, we're discussing whether it's SOGA or CRA. So do not jump in straight to discussing section 13, right? Or section 11, whatever section number now, but deal with the statute that's applicable. Now, to expand further on the applicability of CRA, you find that there are these requirements in order for the Consumer Rights Act to apply. That's firstly, that this must be falling within these types of contracts. It's pretty broad. It could be goods or services, and in fact also including digital content. We have not seen digital content or software for the past 3 years, but there was a question a couple of years back, I think it's 2016, which tested students on software. So please don't assume that all the time it will be goods. It may be software, and it could attract then the discussion of CRA, which is governing software. Whereas please take note, for SOGA, it does not apply to digital content. In fact, SOGA does not even apply to services. SOGA only applies to goods. It's called the Sale of Goods Act. Whereas CRA applies to these 3 statutes, right? And of course, there must be a trader and there must be a consumer. And clearly, because this is a contract for the sale of a painting, goods. Then what about a trader? You have to define it properly. Don't just say that, oh yes, Samson is a dealer, is a trader. Now, that is not a wrong conclusion. But my purpose for this session is to provide you with a structure, to provide you with the substantive law points you want to use to apply to come to a conclusion. So before you come to a conclusion and say that yes, there is a trader because this guy is a dealer, you have to look at the law first. Right? So please do not forget the law that you apply to come to a conclusion. That is how you answer exam questions. And the law is here, where the definition of a trader is found in section 2, sub 2 of the CRA as a person acting for purposes relating to his trade, business, craft, or profession. I've got another lecture which I've recorded, which I may make available to you as well, concerning the difference between the use of the word person here in 2 sub 2 and the use of the word individual in the definition of a consumer in 2 sub 3 afterwards, as well as the focus on purposes. That's a word that I've highlighted in bold in this screen, but purpose is the focus, and all that is something I'll do in a separate lecture recording. But for now, this is pretty straightforward. To apply this to the facts, yes, we are told of Samson being a fine art dealer and he's selling a painting. So a fine art dealer selling a painting, would he be acting within his business? Yes, right? So therefore, a trader is made out. Insofar as whether it's Zhang a consumer, right? So here it's defined also for us in statute, it's in 2 sub 3. And like what I mentioned just now, look at the definition of a consumer. The use of the word is no longer person acting for purposes, but rather an individual acting for purposes. Now, what is the difference between persons versus individual, right? So this will be covered in separate lectures for our revision. Now, but reading further, Zhang is an individual, that's not an issue. And is it acting for purposes outside his trade, business, craft, profession? Now, we are not told of what profession Zhang is, but we are told of what profession he is not in. We are told that he is not an art dealer. He's buying a painting. So clearly this allows us to make this conclusion that this is a consumer. And that is why I said to you that from the onset, if students had identified this question to be a SOGA question, it's wrong, because this is already a contract that satisfies the 3 requirements in order for it to be falling within the Consumer Rights Act. This is a contract for the supply of goods, the painting. We have a trader, that's Samson. We have a consumer, that's Zhang. That's it. CRA will apply, not SOGA. Okay? However, if for any reason, any of these elements for CRA, they are not satisfied, then yes, then we can consider below to seeing whether or not will SOGA apply. In this case, I struck it out. It will not be a SOGA discussion. Let's now continue further with the Consumer Rights Act, right? So the relevant section for the CRA is 11 sub 1. It says goods to match description. It's basically similar and corresponds with section 13 of SOGA, that goods sold must correspond to description. The language used are different if you want to compare the words in the statute and the sections, but essentially it's about goods corresponding, matching, following the description of the goods, right? And for us to discussing this, again, you want to be structured, and there'll be two parts of your answer. The first part is to discussing the prerequisite, whether in the first place, is this a contract for the sale by description? And then secondly, what's a test for the breach? Now let's start with the first. Is it a contract for the sale by description? Now goods must match the description, but what is the description? When the goods were sold, by what description was a goods sold as? Now, why do I want to raise this issue? Because now, in this next slide, you are seeing how there are two descriptive terms, two representations made by the seller. Which is the one to which the goods were sold by? Which is the one that describes the goods? Is it the first one, which is where the seller describes it as follows, where it says it's an important example of the work of Estes, one of the leading photorealists, with excellent provenance. Now, if you examine or dissect this statement carefully, is the seller saying that this is painted by the original artist Estes? No, it's not. In fact, the last two words of excellence provenance itself indicates that there's a possibility it may not be the actual authentic painting painted by Estes. It just says of excellent provenance, not that it is of original provenance. So the authenticity or the originality of the painting at this juncture was not really stated by the seller. Although no doubt he's very convincing and strong in his words, he is saying of excellent provenance, but short of saying it's original. In fact, the earlier part of these few words say what? That is an important example of the work of Estes, which is true. As in, this painting board is by another artist, but it is concerning a photorealist painter type of painting. And so in that regard, if this is the description for the contract, then this will be what the buy has obtained, and there's no breach of implied term. So I need you to not jump straight to discussing the section and concluding there's a breach. You have to be structured. And of course, then to contrast from the other statement that was made in your next paragraph, where subsequently the seller does say that this is a genuine original work, right? And of course, he even goes on further to show the documentation and then says that it confirms that this is the original painting by this artist. So which is which? And I would want to argue, and let's not be presumptuous, we want to present arguments. I want to argue that yes, on one hand, there's an argument that's available, that's indicated in the answer to suggest that, and there's a phrase said right in your answer, in the paragraph, that Zhang, the buyer, collects such paintings from other artists, which means that maybe he's going for the type of painting, not so much as the artist. And if he's going for the type of painting, which he has done so before and from other artists, right now, he has got what he bargained for. So that's one argument supporting this conclusion. However, the other argument and the other conclusion is what you see here now, that we were told in the exam question of how the buyer inspected the painting closely. He checked the documentation. And I think the strongest compelling factor is he paid £60,000 for the painting for one that would otherwise be only worth £2,000. So tell me now, would you think that insofar as the contract for sale of this painting is concerned, is it by this first description of photorealist painting or the painter? It's a photorealist painting by this artist. And I think that the facts are quite compelling, and we're now, having argued, conclude that this is most likely the relevant descriptive term for this contract, that the contract was sold by this description. Okay? Now, having made this conclusion, then now we're going to go on now to discussing the elements that will help us to conclude that the contract was sold by that description, which is the description that we just identified. And there are three elements that we have to satisfy. The first element is that this description concern must be, in the first place, a term of the contract. As opposed to just a mere representation, it must not be a mere representation, but rather an actual contract term. Right? So don't forget now, if you look at this question, the entire question is only one issue, which is on the description issue here. And so you don't have to rush through the answer, discuss the three elements, and now the first element, raise the distinction between representation and contract term, and then to see which one is it and whether would this amount to a contractual term. This is somewhat overlapping with our contract syllabus. Your law of contract, your year 1, level 4 subject, where we would have discussed the contractual cartography guidelines, and where I would have given you, perhaps during our contract lectures, this acronym, STIR, STIR, to capture the factors within this contractual cartography guidelines. S, which stands for special knowledge. Or would it be that the representative has more knowledge, special or more knowledge by the representative, but the seller in this instance? Time of statement. When was it made? Was it made very close in proximity to the time of the contract? Or was it made long time ago before there was a contract? Then the importance of the statement. Is it a type of statement where it's of secondary, ancillary reason or importance? Or really very important? The last one, was it reduced to writing? Now, at this juncture, I will leave it to you now to apply these 4 points in your answer to argue. But I think that you know how this can come to a conclusion. Given the fact that the buyer paid 60,000, would it be important? Quite likely, yes. Was it reduced to writing? Now, we don't know, but possibly, at the very least, we do know that as part of the sale, the documentation was shown to the buyer, and which was that which convinced him to buy. So he didn't buy earlier on, right? He only bought when he examined the painting, when he looked at the documentation, when he was told by the seller it's original, then he bought. So all this indicates or allows us to come to a conclusion that quite likely this will be a contract term. Now, if you, for any reason, conclude it's just a representation, then therefore this will take it outside CRA. Then your answer ends. There's nothing more to discuss. Right? So in that regard, you know how you must discuss this, and that is to satisfy the first requirement. Now then the second requirement or element is that B, that description, whilst it is a term, it must not just be any term, but it must be an essential term of the contract. As terms go, you know a term can just be a mere warranty, or a term can be something fundamental. In this regard, we are now saying that for Section 11 of CRA to apply, it must be an essential term of a contract. And now here would be the cases that you would have learned. This is just a revision lecture, right? So I'll just put down a key point here as a summary main point for purpose of this class. And the case of Acquainted Piggeries, that tells us that the key is identification. And of course, the case of Witness Fifth Line, it came a few years later, and both these cases by the House of Lords say that it must identify what? Identify an essential part, an essential performance of the contract, an essential subject matter of the contract. It must identify what the goods are. And that is what these two cases are about. Now, these two cases are actually not on the CRA. As you would know, these will be cases under SOGA, Section 13, but it's fine. We can use these cases as well under SOGA, the interpreted Section 13 for description, for its same meaning or application for description within CRA. Right? So having a look at these two cases, again, we look back at the term that we are now discussing, where the seller had assured the buyer that based on the documentation, this is a genuine original work. Would you think that this is beyond just a term, a fundamental term? And using the same arguments just now, the fact that he paid 60,000. And before buying, he checked. So before buying, he checked, and then he bought, right? The time of the statement, the time of the inspection, that resulted in him now to then buy. All this suggests, right, that it was important to him. There is not just a term, but a fundamental or important term. So therefore, the second requirement would also be satisfied. Which brings us now to the third and last requirement, and the one that most likely you will spend some time on in this part of the answer. They will be discussing whether was there reliance and was it reasonable to rely on the description. So making the sale to be subject to a descriptive term is not enough. The buyer must have relied, and beyond reliance, it must be reasonable for the buyer to rely. And we saw this in the case of Harlington, Lanston, and Christopher Hull, a case that you must quote. So this is a 3-star case. In fact, the most important case so far, and for this answer, because the case of Harlington also involved a painting by this famous artist, which was a constable painting. However, in the case of Harlington, the court found that Section 13 did not apply. Sale by description was not made out. The buyer was not able to sue successfully. But that was because of its particular facts, such as you see now in your screen, that the seller had made a disclaimer of knowledge. If you examine the facts of the case, from the onset, the seller kept on saying that I am not an expert in such kinds of paintings. Is it by this German artist, Munter? I'm not an expert. So he had been giving such a disclaimer of knowledge. That itself should put the buyer to inquiry, to wonder, then is it really genuine? And whether should he still rely? And if he did, would it be reasonable for the buyer to still rely, despite or when the seller had given such disclaimer of knowledge? Not only that, right, the buyer was an art dealer. This, I think, is to some extent a core fundamental difference between what you see in your exam question and the case of Harlington that students must be able to identify. Because clearly, the status of the buyer makes a lot of difference. Where in the case of Harlington, the court found that the buyer, you yourself are the art dealer, in fact, he specialized in buying such types of paintings. So he should know better. It is not reasonable for the buyer who knows more to still rely on the seller who says that he doesn't know anything. Not reasonable to rely. And that was why Section 13, description, was not made out in this case of Harlington. Whereas in contrast to our current question, you were explicitly told that Zhang is not an art dealer. So for the fact that this was mentioned specifically, you must identify that, pick that up, and use that in your answer, distinguishing from the case of Harlington. The third and a final factor, of course, would be also a very crucial distinction in the case of Harlington, where that buyer in Harlington, because of what the seller had told him, the buyer went on now to obtain independent advice from a German painting specialist. And it was that art specialist who then verified and told him that, yeah, this painting is authentic. And that was when he bought. Again, when you look at now the facts of your question, is totally different. The buyer immediately bought after the inspection and after what the seller tells him. He didn't verify any further. He is not an expert himself. He's a consumer as identified. And so would you think the consumer will rely on an art dealer who shows the documentation, who says such strong words that this is the original painting? Would you think that the consumer will rely? Would it be reasonable for the consumer to rely? And I think the answer would be yes, right? So we want to come to a conclusion that we can distinguish from Harlington, which, by the way, is a similar situation arose in the case called Drake and Agnew. This is a typo. The case name is Drake, as in D-R-A-K-E, Drake and Agnew, right? Also considered a painting, where that case was where there was no breach as well. But you can distinguish, right, Drake from our present question. And so we argue, right, these three things which I mentioned earlier on, about a buyer not being a dealer. Seller, on the other hand, is a dealer. And there's no way, anyway, that a buyer would be able to verify the provenance, the authenticity, based on his inspection. He did not send it for any further inspection, right? And he bought it immediately. Now, the only argument that maybe could be raised, and as part of a good answer to any exam question in law, is that you like to play like a ping pong table tennis game, back and forth, back and forth. So now we have presented some arguments to argue how there is reliance. What could be a counter argument? Right? Let's respond and retaliate with a counter argument. So the only other argument perhaps is this, that maybe it was not reasonable for a buyer to immediately take the painting without any further verification. Surely, before you pay 60,000, you may want to send the painting for checking, perhaps. Now, that's an argument. I suppose, in my case, especially objectively, I suppose also that before I spend 60,000 on what is purportedly an original painting, I want proof that it's original. I won't take your word for it that it's original. I want proof. I want a certificate. It's like, for example, you buy certain branded goods. It comes with a certificate. A Rolex watch, for example, has a certificate, right? And so my point is that you may want to have proof of authenticity, check carefully before you pay, which in this instance, the buyer did not send the painting for any further checking. He bought immediately. Now, but although we raised that, but still, this might not be a very compelling, strong argument, but we raise it nonetheless because, as I mentioned here on the screen, that it's mitigated by the fact that the buyer here is not an art dealer. He's a consumer. And moreover, was it not shown proof? Yes, it's not just mere words. The documentation that we were told in the question that was provided that he examined. So he was already seeing that documentation. What more would you want? And so because of that, that's why the court found that it was reasonable. We will argue that it's reasonable for the buyer to rely, and therefore all the three elements to make up as to what amounts to a contract for the sale of goods by description is satisfied. Section 11 sub 1 will apply. In which case now it brings us to the next part of the answer, which is how do we determine what is a test for when is there a breach? Must you comply with every descriptive word? And so here you notice there are two views, and we would have used a similar structure even if you answer a SOGA section 13 question, where on one hand would be the strict view, which is from the cases of Arcos and Ronaldson, Raymore. Those are the two older cases, but not just old. We have a case of Hazelwood, far more recent, which also confirm a similar strict view, where they are literally saying that every descriptive word must be satisfied. There must be exact conformity to the description. That's why we call this a strict view. In the case of Arcos and Ronaldson, the infamous case, as you may remember, was a case where the description was wooden staves, half an inch. The goods delivered were 7/16 of an inch, 9/16 of an inch. Very, very microscopic difference. In fact, barely noticeable to the naked eye. 1/16 difference of an inch. How would you know? You can't even see it with the naked eye unless you measure. And so it's a very microscopic difference. But this is why we call this the strict view, where the court said that you must comply exactly with the description. Do we use this standard or test? Because we have a contrasting decision taken in these cases, as you see here now, of Ashington Piggeries, Williams Smith Line, the same case we saw just now in the earlier discussion, and even also a much more recent case of Brewer and Mann, right? So we do have, and you should, by the way, wherever possible, support your answer with recent cases. The classic cases of Ashington, Williams Smith Line, Arcos Ronaldson, every student will put down. But are you putting down the recent cases? Now, mind you, Brewer and Mann was a case by the Court of Appeal, right? So it's not as if it's a first instance decision, it's landmark. And if you look at the case of Brewer and Mann, the court took a very broad view, a very liberal view. This was a case concerning a Bentley. They were sold Speed 6 Bentley. But the Bentley, the car, they were sold eventually to the buyer, was not the original Speed 6 Bentley. It was actually a reconstructed engine. And so to the buyer said, I wanted to buy an original Bentley Speed 6. I think it was a 2010 model or something. No, sorry. I forgot the year, but it was very clearly a particular year that he wanted to buy the Bentley. Now, however, the car eventually that he bought, he discovered was with an engine of a different year, not original. And so he sued. But the court says, well, you wanted to buy a Bentley, you have a Bentley. Speed 6 Bentley, Speed 6 Bentley. Even though not original, not of the year you mentioned, doesn't matter. It's like saying you want to buy a horse, you have a horse. A house. Even though the horse is not sound, the house is not inhabitable, doesn't matter. Now, these two last examples of a horse and a house were examples we would have used from a case called Bell and Lever Brothers in the law of contract for the topic of mistake. And the principles there apply here as well. In that, we are now arguing, you want to buy a painting, you have a painting, that is photorealist. There's a good example, illustration of this artist, Estes. Yes, you have that. Now, so which view do we use, right? The strict view or liberal view? And it seems to be inconsistent, isn't it? Now, this was all reconciled in one case called Chai Chewat and SDL. It's a Singapore case, but it's a case that has been mentioned by the UL updates at least on, I think, 3 consecutive years in the past when the case came up, right? 3 years. This was a case kept being mentioned by UL. And this is a case that's landmark, decided by the Singapore Highest Court, the Court of Appeal, and it reconciled these two particular views by the following explanation. By saying that you must look at, firstly, whether the description was one that was detailed, i.e., the more detail that you describe the contract of the goods, then the stricter we expect for there to be conformity to the details. And so that's where now we should use a strict view, as was in the case of Arcos. On the other hand, if this is not so detailed in your description, then the deviation must be more substantial. We don't expect there to be exact strict conformity to everything said. So for example, if I were to sell you a car and you have a car, that's it. It may not be the exact model or year that you were looking for, but you have a car. But however, if the description were very specific, detailed, I want to buy a 2010 model car that belonged to your father, that's blue color, that has a scratch at the side door. Now, if I'm so specific, clearly I'm referring to that car. And therefore, I would need to get that car. Otherwise, there would be a breach of sale by description, right? And so that's how we look at these two factors as provided by the case of Chai Chewat. And in fact, this particular slide you see here now would beautifully explain all the two views and the cases that we saw just now. And again, for time, I won't go through that. This is, after all, one more time of revision, right? But you would be able to use this to nicely reconcile all the earlier cases and the two conflicting positions, and even apply to the facts to come to a conclusion. On the facts of this question, tell me now, would you think that this is where we apply the liberal view or the strict view? I will submit to you this, that if all we discuss or all we have in the question is the earlier statement made by the seller, where it says that this is of an excellent provenance, then I think it's a bit vague. It's just an illustration or an example of the work of such a person, this artist. It's still vague, But in the next paragraph of your question, you were told where the seller went on to provide the documentation, went on to say that this is confirming that this is a work by that artist. Is that specific? And I think that now at this juncture, it is specific. And so we will want to apply section 13 or section 11 and conclude that there is a breach of this impact term. And so the final part of this session or this lecture recording is then to talk about the available remedies for breach. As I mentioned just now, at the beginning, the remedies for the buyer are different from compared to in SOGA. Unlike SOGA, the remedies are only to repudiate the contract and sue for damages. Under the CRA, there are more remedies, what we call the 5 R's in section 19, sub 1 of the CRA. What are 5 R's? This would be the remedy of right of rejection, a short-term right of rejection, the remedy of repair, the remedy of replace, the remedy of reducing price, and one more time, the right of rejection, final rejection. 5 R's. You do not have this similar type of remedies in a way it operates over 3 levels in SOGA. And so you want to be very careful. And incidentally, by the way, if you look at your 2019 October paper, there are actually 2 impact terms questions. One is on SOGA, that's question 5. This one, question 6, is on the CRA. Right? So be prepared in your exam preparation. Be prepared for not just SOGA, which I know is the primary focus in the syllabus, but also possibly CRA, which was this question. Now, let's examine the 5 R's in more detail. And so I mentioned briefly that this works out over 3 levels. So the 5 R's or the 5 remedies are over 3 tiers. The first tier is the short-term right of rejection. Short-term because you have only 30 days. The moment the 30 days comes and goes, that's it, you can no longer reject under the first tier, right? Of course, I have put in some words here which you can slowly take your time to read through. Pause the video to read through this. And moreover, it's all in statute. But the main thing which I want to draw your attention to is this, that whilst we give the buyer 30 days, it's not as if that he must wait till 30 days to reject. That is the maximum for him to fall within the first tier, the 30-day short-term right of rejection. He can reject at any point in time. So this instance where Zhang, the buyer, has discovered it's a fake painting, say maybe after 1 week, then reject straight away, right? Now, so that's really how this first tier works. Moving on further to give you now the rest of the law on this area would be that assuming they did not reject within this period of time. And it's possible because why? It might be that he never discovered the problem until later, right? So then he will lose the first tier, in which case now will be a second tier or second level, which I don't think applies here in this question. The second tier or second level is the right to repair or replace. So whilst repair and replacement of goods are 2 different actions or remedies, but they fall under the same level. Why same level? Because you choose one or the other. Notice the word in red in your screen. It's not one and the other. It's repair or replacement. Now, how do you know which one to choose? I suppose the starting point is that whichever is the one the buyer wants. Sometimes a buyer may want the item to be totally replaced. Why? Because who doesn't want something new? But other times, the buyer may want something to be repaired. For example, maybe this could be a very minor repair. It's a scratch on a car door. You can easily spray over it. It's good as new. Why would you want to replace a whole car for 1 scratch? So it does depend on the circumstance. But what the statute says and what you see here in this screen or on your slide now is that the buyer must choose that remedy which is not disproportionate to the other remedy. It must not be an unreasonable, proportionate remedy to the other. In other words, between the remedies of repair or replace, choose the one that is more reasonable. You cannot choose the one that is disproportionate. So for example, if this is a small scratch, which is very easily rubbed off, use some kind of special cloth to rub it off. That's it. Then choose that. You would not be allowed to choosing a rejection of the goods to ask for a whole full replacement, because then that would make this remedy to be disproportionate to the other, right? So this is an example to show you how repair or replacement work. But in this question, as I mentioned, it does not apply because here the buyer most likely want to reject the goods. Why repair? Nothing to repair, right? The painting is just not what it was. And why replace? Because the seller has nothing to give you. It's not as if the seller gave a wrong painting. So he wants to reject, which is available, and it's a final tier. So the first tier, second tier, the third tier, the final tier now, one more time, is where he now can reject. But this third tier is not just reject. Again, there's a choice either to reduce price or to reject. So maybe it could be that since we were told that this painting is only 2,000, and after all, don't forget now, go back to your earlier paragraph of the question. He is collecting such types of paintings. And he even collects these type of photorealist paintings from other artists. This is one of those other artists, not as famous, worth lesser. So could it be that he may want to be advised to choose price reduction? Yes. And that's my point, right? That you need to know the law and then to apply this. So it's not shown here in this screen, but in your answer, when you write it out, you have to indicate that this is a possible remedy that Zhang may pursue. After all, it seems to be that he does collect such kinds of paintings from other artists. And so, since this painting from this lesser-known artist is only worth 2,000, he will get back 58. Reduce the price and take back 58. But if he really wants to have this original painting from this artist as this, and that he does not want to have any other paintings from other artists, then sure, reject the painting, which is also available as an option to him, right? So I would like you to, as part of your exam preparation, read the statute, right? It's from section 19 of the CRBA onwards, 19, 20, 21, all the way to, I think, 24, right, or 25. But read those sections and it'll give you a very good picture of the three-tier remedy that's available to a consumer buyer. And in summary now, the summary of the three tier will be as follows. The first tier, one more time, is the short-term right of rejection within 30 days. And full refund, get back the money paid. Number two, either choose one or the other, repair, replace. And the third tier, of course, would be a final right of rejection, or if you want to, you can choose to reduce the price. Okay, so with that, we have covered, right, the remedies. And with that, we've also covered more or less the whole answer. But before we end this session, I want to just give you an overview of the CRA remedies. Now, I keep on saying the three tiers, but I want to be more accurate now because I don't want you to study the law wrongly. The three tiers, strictly speaking, only apply to a breaches of section 9, 10, 11, 13, 14, and 16. What you see on the first row. The first row, right, breach of section 9, SQ. Breach of section 10, fitness for purpose. And all those first row impact terms would be where you get a three-tier remedy, right? Reject, repair, replace, reduce price, or reject. However, look at now the second row. In your second row now, where it's breach of section 12, which is also an implied term, also a statutory term in the CRA. If you breach 12, then you have only a right to recover from a trader the amount of cost that you've incurred as a result of the breach, right? So swing for damages. Look at now, again, the third row. If the breach of the statute implied term in CRA is a breach of 15, where the goods were not properly installed, then you have now only the two tiers, no three tiers. Look, finally, right to supply goods, which is right to sell, the equivalent of section 12 of SOGA, right to sell. Here is 17, right to supply. If you breach that, you have this right to reject, only one tier, right? That's it. So please take note that the remedies are all different, and I think that this manner of how I group them together helps you see it very well as a broad overview. But our focus will, of course, be the first row. Your exam questions most likely will be which of section 9 or 10 or 11. That's a very common exam focus. And so if that's the case now, which of 9, 10, 11 of CRA, then you get your remedy, your 3-tiered remedy, as we had discussed, right? So over and above, right, in case you're wondering, well, what about damages, right? I've not mentioned you say anything about damages. Obviously, being a common law remedy, it can write on together with statute. The remedies we've just discovered or discussed are the statutory remedies. The common law remedies are always available so long as there's no double compensation. So as we conclude this answer and you apply all we discussed to the facts, most likely Zhang, upon discovery of the fact it's not an original painting, you can choose to already reject the goods and claim a refund under the first tier. If not, then under the third tier. Okay. So with that, we come to a conclusion for our lectures or for this recording. Thank you so much, and I hope that you found this session useful. Thank you. Hello, hi. I hope that you found that session to be useful and that you could apply that in your coming law examinations. My name is David, and if you're interested to attend more of such kinds of revision classes for your law examinations, for the UL examination, please do click that link that you see below. This will be bit.ly/UL revision BAC, and we'll send you more information. And this will be classes that we are conducting on the law subjects across the board for the UL law examinations. I hope to see you. Thank you.
The world is changing exponentially. Humanity will see more changes in the next 20 years than it has in the past 300. What we do will change. How we do it, even more so. Be ready. Join the education revolution designed to impact and transform lives. Access 300 world-class programs in over 40 areas of study from over 30 international partners and affiliates in an education ecosystem like no other. Become a future-proof global graduate now. Own your future.